Security Guard Training Course, Section 8, Legal Authorities. Overview. It is important for security guards to understand their rights and limitations when performing their duties and to know where they derive the authority to carry out their job functions. Security guards can encounter situations where they need to be familiar with: no persons under 19 years of age shall enter or remain on premises in which the sale of liquor is authorized, if the person knows that a condition of the license or permit for the premises prohibits the entry of persons under 19 years of age. Exceptions to the subs. Subsection 10 does not apply to a person 18 years of age who is employed on premises in which the sale or service of liquor is authorized while the person is on the premises during the course of his or her employment. Unlawful possession or consumption. No person shall have or consume liquor in any place other than a residence, b. premises in respect of which a license or permit is issued, or c. a private place as defined in the regulations. Provincial Offences Act. The purpose of the Provincial Offences Act is to replace the summary conviction procedure for the prosecution of provincial offences, including the provisions adopted by reference to the Criminal Code of Canada, with a procedure that reflects the distinction between provincial offences and criminal offences. Designation of Provincial Offences Officers. A Minister of the Crown may designate in writing any person or class of persons as a Provincial Offences Officer for the purposes of all or any class of offences. Residential Tenancies Act. The purpose of this act are to provide protection for residential tenants from unlawful rent increases and unlawful evictions, to establish a framework for the regulation of residential rents, to balance the rights and responsibilities of residential landlords and tenants, and to provide for the adjudication of disputes and for other processes to informally resolve disputes. They are Trespass to Property Act, provincial legislation, Criminal Code of Canada, Charter of Rights and Freedom. Trespass to Property Act. In this act, the occupier includes a person who is in physical possession of premises, or a person who has responsibility for and control over the condition of premises or the activities they are carried on, or control over persons allowed to enter the premises even if there is more than one occupier of the same premises. Premises means land and structures, or either of them, and includes water, ships and vessels, trailers, and portable structures designed or used for residence, business, or shelter, trains, railway cars, vehicles, and aircraft, except while in operation. School boards. A school board has all the rights and duties of an occupier in respect of its school sites as defined in the Education Act. Trespass is an offense. Every person who is not acting under a right or authority conferred by law, and who a. without the express permission of the occupier, the proof of which rests on the defendant, 1. enters on premises when entry is prohibited under this act, or 2. engages in an activity on premises when the act is prohibited under this act. Arrest without warrant on premises. A police officer or the occupier of premises, or a person authorized by the occupier, may arrest without warrant any person he or she believes on reasonable and probable grounds to be on the premises in contravention of Section 2. Delivery to police officer. Where the person who makes an arrest under subsection 1 is not a police officer, he or she shall promptly call for the assistance of a police officer and give the person arrested into the custody of the police officer. Deemed arrest. A police officer to whom the custody of a person is given under subsection 2 shall be deemed to have arrested the person for the purposes of the provisions of the Provincial Offences Act, applying to his or her release or continued detention and bail. Criminal Code of Canada. Definitions of offense classes: indictable offense, summary offense, hybrid class offense, protection of persons acting under authority, excessive force, use of force to prevent commission of offense, duty of person arresting, self-defense against unprovoked attack, preventing assault, defense of house or real property, assault, mischief, arrest without warrant, possession of property obtained by crime, criminal harassment, break and enter. Definitions of offense classes and indictable offenses. An indictable offense is more serious than a summary conviction offense. Conviction of an indictable offense exposes you to greater penalties. If you are prosecuted by indictment, you are entitled to trial by jury for most offenses. You do not have the right to trial by jury if you are tried by indictment for offenses such as drive disqualified, i.e., driving while prohibited as a result of a conviction for impaired driving, theft under $5,000, fraud under $5,000, or mischief under $5,000. Following conviction of an indictable offense, you must wait 5 years before pardon eligibility. Summary conviction offenses. Summary conviction offenses encompass the most minor offenses in the criminal code. Examples are communicate for the purpose of obtaining the sexual services of a prostitute, cause disturbance, and harassing telephone calls. Unless a different penalty is specified, summary conviction offenses are punishable by a fine of up to $5,000 or 6 months in jail, or both. Also, if you are convicted of a summary conviction offense, as an adult, you are eligible for a pardon 3 years from the time you complete your sentence. Hybrid offenses. Many offenses can be prosecuted either by summary conviction or indictment. The Crown chooses or elects the mode of prosecution. Such offenses are referred to as hybrid or Crown option or dual procedure. Hybrid offenses include impaired driving, assault and theft under $5,000. Hybrid offenses are considered indictable until the Crown makes its election. Section 494. Arrest without warrant. Security guards' authority to conduct arrest. Anyone may arrest without warrant: A, a person whom he finds committing an indictable offense, or B, a person who on reasonable grounds he believes 1. Has committed a criminal offense, and 2. Is escaping from and freshly pursued by persons who have lawful authority to arrest that person. Arrest by owner, etc., of property. Anyone who is A, the owner or a person in lawful possession of property, or B, a person authorized by the owner or by a person in lawful possession of property, may arrest without warrant a person whom he finds committing a criminal offense on or in relation to that property. Delivery to peace officer. Anyone other than a peace officer who arrests a person without warrant shall forthwith deliver the person to a peace officer. Protection of persons acting under authority. Everyone who is required or authorized by law to do anything in the administration or enforcement of the law, A, as a private person, B, as a peace officer or public officer, C, in aid of a peace officer or public officer, or D, by virtue of his office, is, if he acts on reasonable grounds, justified in doing what he is required or authorized to do. Item. Where a person is required or authorized by law to execute a process or to carry out a sentence, that person or any person who assists him is, if that person acts in good faith, justified in executing the process or in carrying out the sentence, notwithstanding that the process or sentence is defective, or that it was issued or imposed without jurisdiction or in excess of jurisdiction. When not protected. Subject to subsection 4, a person is not justified for the purposes of subsection 1 in using force that is intended or is likely to cause death or grievous bodily harm unless he believes, on reasonable grounds, that it is necessary for the purpose of preserving himself or anyone under his protection from death or grievous bodily harm. When protected, a peace officer who is proceeding lawfully to arrest with or without warrant any person for an offense for which that person may be arrested without warrant, and everyone lawfully assisting the peace officer is justified if the person to be arrested takes flight to avoid arrest, in using as much force as is necessary to prevent the escape by flight, unless the escape can be prevented by reasonable means in a less violent manner. Excessive force. Everyone who is authorized by law to use force is criminally responsible for any excess thereof according to the nature and quality of the act that constitutes the excess. Use of force to prevent commission of offense. Everyone is justified in using as much force as reasonably necessary, a. to prevent the commission of an offense, 1. for which, if it were committed, the person who committed it might be arrested without warrant, and 2. that would be likely to cause immediate and serious injury to the person or property of anyone, or b. to prevent anything being done that on reasonable grounds he believes would, if it were done, be an offense mentioned in paragraph A. Duty of person arresting. It is the duty of everyone who executes a process or warrant to have it with him where it is feasible to do so, and to produce it when requested to do so. It is the duty of everyone who arrests a person, whether with or without a warrant, to give notice to that person where it is feasible to do so, of a. the process or warrant under which he makes the arrest, or b. the reason for the arrest. Self-defense against unprovoked assault. Everyone who is unlawfully assaulted without having provoked the assault is justified in repelling force by force if the force he uses is not intended to cause death or grievous bodily harm, and is no more than is necessary to enable him to defend himself. Everyone who is unlawfully assaulted and who causes death or grievous bodily harm in repelling the assault is justified if a. he causes it under reasonable apprehension of death or grievous bodily harm from the violence with which the assault was originally made or with which the assailant pursues his purpose, and b. he believes on reasonable grounds that he cannot otherwise preserve himself from death or grievous bodily harm. Preventing assault. Everyone is justified in using force to defend himself or anyone under his protection from assault, if he uses no more force than is necessary to prevent the assault or the repetition of it. Extent of justification. Nothing in this section shall be deemed to justify the willful infliction of any hurt or mischief that is excessive, having regard to the nature of the assault that the force used was intended to prevent. Defense of house or real property. Everyone who is in peaceable possession of a dwelling, house, or real property, and everyone lawfully assisting him or acting under his authority, is justified in using force to prevent any person from trespassing on the dwelling, house, or real property, or to remove a trespasser therefrom if he uses no more force than is necessary. Assault by trespasser. A trespasser who resists an attempt by a person who is in peaceable possession of a dwelling, house, or real property, or a person lawfully assisting him or acting under his authority to prevent his entry or to remove him, shall be deemed to commit an assault without justification or provocation. Assault. A person commits an assault when a. without the consent of another person, he applies force intentionally to that other person, directly or indirectly. b. he attempts or threatens by an act or a gesture to apply force to another person, if he has or causes that other person to believe on reasonable grounds that he has present ability to effect his purpose. Or c. while openly wearing or carrying a weapon or an imitation thereof, he accosts or impedes another person or begs. Application. This section applies to all forms of assault, including sexual assault with a weapon, threats to a third party, or causing bodily harm and aggravated sexual assault. Consent. For the purposes of this section, no consent is obtained where the complainant submits or does not resist by reason of a. The application of force to the complainant or to a person other than the complainant, b. Threats or fear of the application of force to the complainant or to a person other than the complainant, c. Fraud, or d. The exercise of authority. Accused's belief as to consent. Where an accused alleges that he believed that the complainant consented to the conduct that is the subject matter of the charge, a judge, if satisfied that there is sufficient evidence and that, if believed by the jury, the evidence would constitute a defense, shall instruct the jury, when reviewing all the evidence relating to the determination of the honesty of the accused's belief, to consider the presence or absence of reasonable grounds for that belief. Mischief. Everyone commits mischief who willfully a. Destroys or damages property, b. Renders property dangerous, useless, inoperative, or ineffective, c. Obstructs, interrupts, or interferes with the lawful use, enjoyment, or operation of property, or d. Obstructs, interrupts, or interferes with any person in the lawful use, enjoyment, or operation of property. Mischief in relation to data. Everyone commits mischief who willfully a. Destroys or alters data, b. Renders data meaningless, useless, or ineffective, c. Obstructs, interrupts, or interferes with the lawful use of data, or d. Obstructs, interrupts, or interferes with any person in the lawful use of data or denies access to data to any person who is entitled to access thereto. Punishment. Everyone who commits mischief that causes actual danger to life is guilty of an indictable offense and liable to imprisonment for life. Possession of property obtained by crime. Section 354. Everyone commits an offense who has in his possession any property or thing, or any proceeds of any property or thing, knowing that all or part of the property or thing, or of the proceeds, was obtained by or derived directly or indirectly from a. The commission in Canada of an offense punishable by indictment, or b. An act or omission anywhere that, if it had occurred in Canada, would have constituted an offense punishable by indictment. Section 355. Everyone who commits an offense under Section 354 a. Is guilty of an indictable offense and liable to imprisonment for a term not exceeding 10 years, where the subject matter of the offense is testamentary instrument, or the value of the subject matter of the offense exceeds $5,000, or b. Is guilty. Breaking and entering with intent. Committing offense or breaking out. Section 348. Everyone who a. Breaks and enters a place with intent to commit an indictable offense therein, b. Breaks and enters a place and commits an indictable offense therein, or c. Breaks out of a place after 1. Committing an indictable offense therein, or 2. Entering the place with intent to commit an indictable offense therein is guilty. D. If the offense is committed in relation to a dwelling house of an indictable offense and liable to imprisonment for life, and e. If the offense is committed in relation to a place other than a dwelling house of an indictable offense and liable to imprisonment for a term not exceeding 10 years, or of an offense punishable on summary conviction. Criminal harassment, Section 264. No person shall, without lawful authority, and knowing that another person is harassed or recklessly as to whether the other is harassed, engage in conduct referred to in subsection 2 that causes that other person reasonable in all circumstances to fear for their safety or the safety of anyone known to them. Prohibited conduct. The conduct mentioned in the subsection 1 consists of a. Repeatedly following from place to place the other person or anyone known to them, b. Repeatedly communicating with, either directly or indirectly, the other person or anyone known to them, c. Besetting or watching the dwelling house or place where the other person or anyone known to them resides, works, carries on a business, or happens to be, or d. Engaging in threatening conduct directed at the other person or any member of their family. Punishment. Every person who contravenes this section is guilty of a. An indictable offense and is liable to imprisonment for a term not exceeding 10 years, or b. An offense punishable on summary conviction. Causing disturbance, indecent exhibition, loitering, etc. Section 175. Everyone who, a. Not being in a dwelling house causes a disturbance in or near a public place, 1. By fighting, screaming, shouting, swearing, singing, or using insulting or obscene language, 2. By being drunk, or 3. By impeding or molesting other persons, b. Openly exposes or exhibits an indecent exhibition in a public place, c. Loiters in a public place and in any way obstructs persons who are in that place, or d. Disturbs the peace and quiet of the occupants of a dwelling house by discharging firearms, or by other disorderly conduct in a public place, or who, not being an occupant of a dwelling house comprised in a particular building or structure, disturbs the peace and quiet of the occupants of a dwelling house comprised in the building or structure by discharging firearms, or by other disorderly conduct in any part of a building or structure to which, at the time of such conduct, the occupants of 2 or more dwelling houses comprised in the building or structure have access, as of right or by invitation, express or implied, is guilty of an offense punishable on summary conviction. Charter of Rights and Freedoms. Life, liberty, and security of person. Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. Search or seizure. Everyone has the right to be secure against unreasonable search or seizure, detention, or imprisonment. Everyone has the right not to be arbitrarily detained or imprisoned. Arrest or detention. Everyone has the right on arrest or detention, a. To be informed promptly of the reasons thereof, b. To retain and instruct counsel without delay and to be informed of that right, and c. To have the validity of the detention determined by way of habeas corpus and to be released if the detention is not lawful. Tort law. Tort law is often referred to as common law. In common law, assault is the tort of acting intentionally and voluntarily, causing the reasonable apprehension of an immediate harmful or offensive contact. Because assault requires intent, it is considered an intentional tort as opposed to a tort of negligence. Actual ability to carry out the apprehended contact is not necessary. An assault can take place with a toy gun, for example. In security, this could apply to the application of handcuffs to an individual. It is reasonable to assume, once a person has been arrested, that handcuffs might be applied if the person constitutes a danger to the security guard, him or herself, or the general public at large. It also presumes that once a person is under these conditions, arrest, that the arresting person is responsible for the arrested party's health and safety.